Whether you are getting started with a will or a loved one has recently passed away and you're trying to figure out the next steps for their estate, you may be wondering, what is the difference between a small estate and a full estate? And also, how long will the estate administration process take? Okay, first things first. In North Carolina, small estate isn't necessarily a legal term. Small estate means that you will have a streamlined or a straightforward probate process. Now, for simplicity's sake, when I reference probate or probate assets, what I mean is the court estate administration process and the assets that are subject to that court estate administration process. Typically, assets with beneficiary designations are not included in probate assets. What this means is that they are not included in the total value of the estate. Now, when I say probate assets, what I mean are bank accounts with no beneficiary designations, cars, investment accounts, and personal items such as household furnishings, jewelry, and the like. So let's talk about the different small estate filings that are available. First in line is what is called the spousal years allowance. Now, you may file this if it has been less than a year since the deceased spouse has passed away, and if the total assets of your deceased spouse is under $60,000. If the deceased individual is survived by any children under 18 years of age, then their legal parent or guardian can claim up to $5,000 using a dependence allowance. What this means is that a surviving spouse can claim up to $60,000 in assets using the spousal allowance and an additional $5,000 of dependence allowance by participating in a streamlined probate process. If you are not a surviving spouse or a dependent of a deceased individual, but the probate estate has a value of less than $20,000, you may be able to complete a streamlined probate process called collection by affidavit. This process typically takes 90 to 120 days to complete. And sometimes this can even be included with the spousal years allowance and allow a surviving spouse to claim a total of $80,000. However, the catch is that if the total probate asset value is even $1 over $20,000, then collection by affidavit is not available. The bad news is, if the total probate assets are above the figures I just listed, then a full estate administration process will be required. This means that additional steps and additional court documentation will be required. Now, how long a full estate administration process will take and how difficult it will be is hard to determine, but it will depend on a variety of factors, such as the size of the estate, the types of assets involved, and the amount of debt that the deceased individual has accumulated. Typically, a full process takes around a year to complete, but in some instances, it can take longer. Now, I know this can be confusing and overwhelming. We get it. We walk clients through the estate administration process daily. Please reach out to our office and we will be happy to provide a guide to estate administration and also a checklist of items to complete immediately after a loved one has passed away.